Thank you so much, and it's so nice to be here. If you look in the FAR, the Federal Acquisition Regulation, that name has changed to Service Contract Labor Standards. So if you see SLCS, Service Contract Labor Standards, SCLS, that is synonymous with the SCA. So just wanted to make sure that you guys know that out of the gate. And thanks to the introduction, again, my name is Nicole Atala. I am the chair of the Labor and Employment Group at Blair Mazza. We're a full-service business law firm. A majority of our clients are government contractors. So we do kind of nuts and bolts of all legal needs related to companies that are doing business with the federal government. But let's, we have kind of an hour and a half today. I'd really like to structure this to get through the content and to leave plenty of time for you all to answer any questions that you might have. This is really an issue spotting exercise for those of you that either are doing work with the federal government or that might want to do work with the federal government. Many of your contracts could include the SCA, and it's a prevailing wage law that applies to workers that are engaging in services under and in connection to these contracts. There's also some, regulations that are SCA adjacent. And what do I mean by that? They're not codified, they're not contemplated by the SCA legislation itself, but over time they have been promulgated usually by executive order and apply to contracts, primarily SCA and Davis-Bacon Act type contracts. So we're going to talk about a couple of those as we go through today as well, because you can't really understand the SCA without understanding those things. So that's kind of my goal today. It's by the end of this, one, to give you a basic understanding of what the SCA is and does and its requirements, and to really be able to issue spot when you might have a problem or something unique that you might need a little bit of additional help with. So the McNamara-O'Hara Service Contract Act of 1965 is, as its name suggests, a fairly old statute. And the principal requirements of that statute have not changed since 1965. You can think about the last 2 years and how much the workforce has changed. You can imagine how much it's changed since 1965. The ways that we work changed since 1965. So some of the SCA requirements seem a little bit archaic, but and they're not really keeping up as well as they could with the times, but there are some reasons for that. We'll talk about that today. It requires general contractors and subcontractors providing services on prime contracts with the United States and the District of Columbia. So the District of Columbia gets wrapped in often with federal contracts. So DC contracts, unlike say a Maryland state or a Virginia state contract, you might see SCA provisions in those contracts. The contract has to exceed $2,500 for the contract. You can imagine that's pretty easy to do. And the contract has to be performed in the United States. Some territories also will include the SCA, but we're not talking about typical ACONUS type work that is outside of the United States, like in Europe or the Middle East or something like that. The implementing federal acquisition regulation is 52222-41. There are some associated FAR provisions that we'll talk about as we go through today as well. So again, as I mentioned, it has to be a contract that's entered into by the federal government or the District of Columbia. It has to be principally for services. So we usually say a 20% rule, but this isn't defined in the regulations, right? So it really has to be principally for non-exempt service type work. So people that are performing work on an hourly type basis. And the contracting office is supposed to be looking at whether the contract is principally for services, but it's not a over 50% rule. It's a fairly low threshold. It's got to be performed in the United States through the use of service employees. There are some limited exceptions to this. Concessions, commercial type services where you're like doing credit card processing, things like that. Water, utilities might be excluded from the SCA, but generally speaking, if it's a service, it's going to be covered by the SCA. So who's a service employee, right? So a service employee can be anyone that's engaged in the performance of a contract. Sometimes this is really easy to identify because the person will be, sitting in a chair next to government employees at a government work site. Other times the work site is moving around, you're going to it, or you might have a work location where you have employees operating out of that contract. So in some circumstances, you might have employees that work sometimes on an SCA contract and sometimes not on an SCA contract. But we're really looking for those people that are performing work that's under the statement of work in that contract. And it can be an employee or an independent contractor. So the SCA makes it very clear that regardless of the contractual relationship, these prevailing wage rules are going to apply. And sometimes that can be difficult, right? Because some industries are heavily independent contractor type industries where the industry has evolved to really rely on independent contractors. And these workers have, situated their lives around being independent contractors, right? So if that is your case, you want to be looking at those independent contractor agreements. And most everything in the SCA can be distilled down into a dollar value. So there's ways that you can ensure that that independent contractor agreement accounts for all of the requirements we're going to be talking about today. The biggest exemption to this is those that qualify for an exemption under the Fair Labor Standards Act, and that's at 29 CFR Part 541. But essentially that is, whether you classified someone properly as exempt salaried or hourly non-exempt, okay? And if you qualify for an exemption, then you don't have to pay that employee or worker overtime, time and a half over 40 hours a week. But special rules apply to this, to qualifying as an exempt or non-exempt employee. And when I do 2-day trainings, yes, you can do a 2-day training in the Service Contract Act. The first chunk of the training that I give is really devoted to whether someone is classifying employees correctly as, exempt or non-exempt under the Fair Labor Standards Act. Because if you don't get that step right, then you're not going to be able to determine whether, someone should be paid these prevailing wages or not. Because you classify them as exempt, you give them a salary, they're kind of on their way. The Department of Labor comes in and says, that SCA bar clause is in your contract. I think that they're non-exempt hourly, which means that they should have been provided these wages and fringe benefits. And then you're kind of can be in an uncomfortable situation regarding back pay. I like to think of the SCA in two kind of buckets. What's the agency's responsibility and what is the employer's responsibility? So the agency's responsibility is really to determine that SCA applicability, okay? So when the agency puts out a solicitation, one of their responsibilities is to determine which FAR clauses, which Federal Acquisition Regulation provisions, should go into that contract. That's where they would determine, is this a contract principally for services? Is this contract being performed in the United States? Or is this a construction contract that's subject to the Davis-Bacon Act, for example? Or is it a professional services contract or a supplies contract? So that's where that is supposed to happen at that agency level. They put out that solicitation, and at that point in time, if you see that the agency might have made a mistake, that you think it's principally for services, or wait a second, why did they include the SCA in that contract? That's where you as a company should be responding in Q&As or engaging in what we call a pre-award protest to say, hi agency, I think you got the solicitation wrong. I think there's a solicitation defect. So if you're in that position where you think there could be a problem with how those FAR provisions are applied to that solicitation, that pre-bid phase is really where you want to explore that. You want to call legal counsel or address it with the contracting agency, but you really want to make sure you fix those defects on the front end because they can cause you a lot of problems on the back end if you don't get them fixed. If they determine that the SCA is applicable, they're going to incorporate the FAR provision, 52222-41. They also should include a FAR provision called 52222-43, which is the price adjustments clause, she'll talk about a little bit later on, but it gives you the ability to ask for price adjustments to your contract price if the wages and fringe benefits under the SCA go up over time. So it's an important provision. They're also supposed to provide the correct area-wide wage determination. And this is going to be a long laundry list of classifications that's attached, usually as an exhibit to the contract. Sometimes you'll see a wage determination referenced by its number, and then they'll point you to the website where you can get these wage determinations. You'll see on this slide, if they do not get your own WD. The SCA is a creature of contract. What's in your contract controls? You must have the FAR clause, you must have the WD. There is also a provision called place of performance unknown, where you have the discretion about where to put people. This is pretty common in like call centers, you know, where it doesn't really matter where the work is performed. The agency just needs the work done. And in those cases, you would sometimes go get your own wage determination and have the contracting officer incorporate it on award. But you need one of those two things, either the wage determination or an indication that the place of performance is unknown and what they're going to do about it. You should not assume that you know what the wages and fringe benefits are, because sometimes they get it wrong, and it really does impact, you know, really the life cycle of what wages and fringe benefits should apply. There are also two wage determinations for every single, there are two wage determination numbers for kind of each wage determination. These are done by locality, by county. And there's an odd numbered and an even numbered wage determination. So you want to, and they have different implications on how to pay benefits. So you want to, again, don't assume that you know which applies to you. When I say that the Christian doctrine is not applicable, I mean it's exactly that you don't have to read in, you don't have to make assumptions about what should be included in your contract. That's different than some OFCCP obligations. For example, that's the EEO requirements for the equal employment opportunity requirements for federal contractors. Those can be read into contracts regardless of whether they're in your contract or not. The government says you should know they apply to you. The SCA is not that type of regulation. It has to be in your contract. So what's the contractor's responsibility? Well, first of all, you've got to classify people correctly, okay? And I'm going to show you just a screenshot of a wage determination here in a minute. But there's a number of wage classifications that are listed. And you are going to go and look at the Directory of Occupations, which is out there on the good old World Wide Web. And it's called the Directory of Occupations, 5th edition. It's on the Department of Labor's website. You pick a wage determination, you go down the wage determination, you say, I think landscaper fits, or I think, you know, administrative assistant fits, or whatever the case might be. And you're going to check that against the Directory of Occupations description that's in that Directory of Occupations, okay? That's the wage rate that you're going to pay, the minimum wage rate that you're going to pay that classification. And you can pay higher than it, but you can't pay lower. You're also supposed to notify employees of their wages and benefits. What happens though if you can't find an appropriate classification in the wage determination or on the Directory of Occupations? That's when you have to do this kind of funky process called a conformance process, where you pull this conformance sheet and you fill out the worksheet and it says, hey, this is what this person does. I don't think there's a correct classification for them, and this is how much we think they should get paid. You have to have an employee sign it, the contracting officer sign it, and then you submit it to the Department of Labor, where they will determine if in fact they think that this position is unique, or whether there is some other position that would apply to these folks. If you've never done a conformance and you think you need one, I would highly suggest you get a little bit of help, because, you know, more often than not, DOL does come back and say, no, we think there's something close enough, but it is a process you have to work through. You have to pay at least the required hourly rate and benefits as set forth in that wage determination. You also have to maintain a record of all hours worked on that contract, maintain pay records for any worker associated with that contract. And then there's this little tiny thing at the end that I kind of threw in about the minimum wages for government contractors. So I thought this was an appropriate time to mention that there is an executive order, 14026, there was a predecessor to it as well, that set forth a minimum wage rate for government contractors on SCA contracts. So you have, and now's a good time to show you, a wage determination. This is what the wage determination looks like. This is kind of an old one, it's from 2012, so the newer ones have some additional language regarding sick leave and things like that. But I just really wanted you to get the sense of what it kind of looks like. They're like 8, 9, 10 pages long, so I just included the first and the last page here. It has this, kind of the list of wages, and then at the very end, it outlines what the health and welfare obligation is, which we'll talk about in a few minutes. It outlines what the vacation obligation is and what the holiday obligations are in the contract. The new WDs also include the sick leave requirement, and they include this language regarding minimum wages for government contractors. So in addition to these wage rates, there's a base minimum wage that you cannot go under, okay? So, and this is one of those associated FAR provisions that's not codified in the SCA itself. It was an Obama era minimum wage rule that was implemented. It was at the time called the 1010 minimum wage rule. And it basically said if there is any classification on a wage determination that is under 1010, then you have to pay 1010. Well, the Biden administration then came along last year and said, hey, wait a second. We think that that really should be higher than that. We think it should be $15 an hour. So this year, as you get new contracts or your options are extended on contracts, you will see a FAR provision 52222-52, minimum wage for contract workers under Executive Order 14026, and it will say you have to pay at least $15 an hour. So if you use, and albeit an old wage determination here, but if you use this wage determination and you see an accounting clerk one is making $12.46, and you have that FAR provision, that minimum wage FAR provision in your contract, you have to think to yourself, wait a second, I have to be paying at least $15 an hour on this contract. I can't pay the $12.46, I've got to pay $15. And that's applicable across the board on all SCA contracts. What's important though is that you need to remember that the contract has to have that new 52222-52 minimum wages for contract workers under 14026, and your new wage determination will also have language regarding that minimum wage. But the FAR provision is important. It needs to be included in your contract. And if that FAR provision is modified into your contract, as well as any new wage determination might be modified into your contract, you're entitled to a price adjustment for those changes to that wage determination, which we'll talk about in a little bit here. So just keep that in mind. It's a little bit confusing the way they've done it, but the $15 minimum wage will be coming into play all throughout this year. It also increases on an annual basis by the Consumer Price Index. So at about November of every year, the Department of Labor issues kind of the new applicable minimum wage for government contractors. And as that goes up, your obligations to increase rates could go up as well. Again, when it does, you would be eligible for a price adjustment, but you should keep in mind that it will make your price adjustments a little bit difficult over time because you'll have this annual on January 1st possible increase in the wage rate. And then at your option years, you might get a new wage determination that could change like your health and welfare rate or your holidays or something else, and you would have another price adjustment to submit. So it's good to talk to your contracting office about how they want to handle those things. The wage determinations, as I mentioned earlier, there are two different kinds. Most wage determinations you'll see should be odd numbered, not even numbered. Even numbered wage determinations is the last two numbers of the wage determination number, and I've got some examples here, like 2012-2019 is odd, 2012-2020 is even. Most all that the classifications and wage rates are the same on both of the wage determinations, but the even wage determinations harken back to an era where you could average your H&W across all employees to satisfy the average H&W amount. We can't do that anymore. We've got to do per person calculations. So it used to be in the good old days in the 80s, you would say, you know what, if 25 out of the 40 people accepted my healthcare offering, if I average how much I'm spending on healthcare across all my employees, even though several of them did not take my healthcare, I still meet the, health and welfare requirement. They changed that in the 90s and said, no. I think it was the 90s. I could be wrong about that, but I think it was the 90s. They changed that, and it's now a per person calculation. So each person has to receive the correct amount of health and welfare, but it's a max of 40 hours a week. So if you look on the wage determination, there will be a little piece, I'll just flip back to it, where it says health and welfare. And again, this one's old. This one says, 371, but there's a health and welfare rate on there. Today's rates should be, there will be two of them. If the sick leave executive order, which we'll talk about in a few minutes, applies to your contract, it will be for 423, and if it doesn't, it's 460. That's the amount in health and welfare you would need to pay for each hour paid up to 40 hours a week for health and welfare. When would you ever see an even numbered wage determination? Well, you would only see them on legacy contracts. So contracts where it's the same contract that's been going on and on, just with a different number for a very long time, and has one of these legacy wage determinations in it. More often than not, I see them as mistakes. The contracting officer might pull the wrong wage determination, answer one of the questions wrong when the system is, you go through the system and you answer questions in order for it to pull a wage determination for you. And if one of those questions gets answered incorrectly, it spits out the wrong wage determination. So more often than not anymore, I see them as mistakes. So if you see an even numbered wage determination, it's a good thing to flag and make sure that it's correct. Most all of them should be odd numbered. There are also kind of funky wage determinations, for lack of a lawyerly word. They're called non-standard wage determinations, nationwide wage determinations, where the Department of Labor might issue one wage determination for all types of different states for one type of classification. There also might be collective bargaining agreement wage determinations. If there is a organized or unionized work site on a site, they will use their collective bargaining agreement as the wage determination. So if you see a CBA and you are not used to dealing with unions, you should factor that into how you will manage that contract, because you will have an obligation to engage with that union, to negotiate in good faith with them, just like you would if you were the successor, you bought a plant that had a union on site. Some slight differences there, but you should really get some help if you've never dealt with a unionized workforce and are walking into that. It's a little different how you handle this. So the SCA requires that you provide an enforceable wage rate for each classification that's employed on the contract. You're classifying each person, you're using that directory of occupations. One person can perform multiple jobs, and if they do that, it's critical that you either pay them the highest rate in all the work that they perform, or you can segregate those duties well. They're putting in 4 hours for this duty, for this classification, 4 hours for another classification, and it's clearly segregable work so that we can justify to the Department of Labor why they have multiple classifications and multiple wage rates. This is that conformance process I talked to you about a little bit earlier. When there is no classification that fits, you would again go out and get that SF 1444, fill it out, make sure that the added classification, you have to figure out what general broad occupational category it goes in, how much you think the person or the work should be paid at, and then there's a little box to fill out their job responsibilities. Oops, sorry about that. I'm accidentally touching my touchpad. So let's talk about health and welfare for a minute. Health and welfare, again, is that rate that you see on the wage determination that says this is how much you have to discharge in benefits to these employees. And you will see two general rates, 423 and 460. The 423 applies if you are required under the regulations to provide sick leave, and we'll talk about sick leave in a few minutes. But there will be a FAR provision in your contract, 52222-62, which indicates to you that you have to provide a certain amount of sick leave. If that is the case, then you pay 423. If you do not have the sick leave provision in your contract, you're going to pay the higher rate, 460. This is not a choice. So you can't choose to not provide sick leave and just use the higher H&W rate. That's a common misconception. You're kind of locked in. If the DOL investigated and said, well, you know, you didn't provide sick leave, but congratulations, you provided 460 in benefits, they would just say that you've exceeded the amount that you had to pay, but lucky for your employees, you're a really generous employer. That's kind of the approach they take. These are minimums, not maximums. Hawaii has kind of a different, another set of H&W rates. So if you pick up a contract in Hawaii, the amount you pay will depend on whether you participate in Hawaii's prepaid healthcare plan. So it's important to understand if you're required to participate in that healthcare plan, and if someone is receiving that healthcare, there is yet another rate that you would be eligible to pay. H&W, when you total it all together, it's the total of all benefits you're not legally required to pay except for vacation and holidays. So vacation and holidays are handled separately. You cannot count the vacation and holidays provided under the SCA towards your H&W benefit. They are separate and distinct benefits. You can provide cash or a bona fide benefit, and it's your choice as an employer what package you provide. These are, a lot of employees will say, well, that's my H&W, I want it in cash. That's not how this works. The employer decides what benefits to provide, and as long as it's a legally enforceable obligation that's communicated to the employee in writing that you are going to provide a certain amount of benefits and how you're going to provide them, it's at your discretion. If you pay the H&W in cash, however, you must segregate that amount in the pay record. So it has to be indicated and on a separate line item. If you aggregate the two amounts together and you just, you take the wage rate plus the health and welfare and pay it, and you don't separate it on the pay stub, DOL will assume that you did not pay H&W. They will charge that back again. They will say, well, you just exceeded the minimum wage rate. That's a very uncomfortable position to be in, and it's very costly. This also applies to part-time employees. So you can't say, well, we don't provide benefits to part-time employees. Well, you need to provide at least this level of benefit, even if you pay it in cash, again, segregated on the pay stub. You will, if you're over 50 employees, there will be discussions, I'm sure, with your benefit provider about your requirement to offer bona fide essential coverage under the Affordable Care Act. There are some workarounds for SCA folks. You have to offer healthcare coverage, but the affordability requirement can be satisfied by a cash contribution. So if you're in that boat and you're over 50 employees, but you also have SCA contracts, you might want to talk to either legal counsel or benefits counsel about what your options are and whether to include them in your regular pool or not. Your bona fide, I just listed some examples of the type of benefits that you could include here. Could be health insurance, life, disability, dental, vision, accidental death, sick leave. You could provide more sick leave that's required by the executive order, or if you are not subject to the sick leave executive order, you could provide sick leave. 401k or pension contributions, educational assistance, additional vacation or holidays. So you could provide more vacation, more holidays than the SCA already requires, jury duty, bereavement leave, and again, cash in many circumstances. Health and welfare usually increases every year. In 2020, I don't think it increased because no one was going to the doctor in 2020, but usually it increases in July, August. The Department of Labor will issue new wage determinations, but employees are not entitled to an increase unless and until that contract is modified to include the new wage determination. So just because DOL issues a notice that says, hey, H&W is going up a few cents an hour, your employees know that immediately. It spreads like wildfire. But they are not entitled to an increase unless the contracting officer modifies your contract to include a new wage determination. They're supposed to do that at the option year, but they're no less than every 2 years. Then you, as the contractor, within 30 days of getting that modification, you request a price adjustment from the contracting officer for the actual difference in rates, basically your cost impact, right? So if you were paying $15 an hour and the wage rate goes up to $15.20, you get the 20 cents an hour plus FICA, FUTA, SUTA, workers' comp. You don't get G&A, overhead, and profit. Same with health and welfare. It's based on what you are actually paying, though. So if you're paying above the minimum and you are not going to get, you're not going to get the wage determination to wage determination comparison. You're going to get what you're paying now and can demonstrate that you're paying versus what you have to pay as a result of the contract modification. So that's important to keep in mind. So let's talk a little bit about sick leave while we're talking about benefits. FAR 52222-62 is the provision that implements sick leave requirements for federal government contractors. The covered employees include employees working on or in connection with a covered contract. So a Service Contract Act contract, a Davis-Bacon Act contract, those are the types of contracts that include the sick leave provisions. They should be in any solicitation issued after January 1st, 2017. So we're starting to see those changes. And once it's in your contract, it is going to apply to everyone on that contract. So this is the part that gets a little confusing. The SCA is what triggers the requirement to put that FAR clause in your contract. But once it's in the contract, it applies to everyone, whether they're hourly or salaried or working at the home office 20% or more of their time on these covered contracts. For the non-exempt SCA people, you really should have a separate sick leave bucket. You should have a sick leave bucket and a vacation bucket because those two things work so differently under the SCA. For your exempt staff, your salaried staff, your home office staff, you can, if you would like, use a PTO policy and combine your vacation and sick leave. So it helps contractors because they don't necessarily have to pay more than what they're already paying. It should accrue to people at 1 hour for every 30 hours worked or 56 hours a year maximum. You could also front load those hours if you so chose to front load them. You do not have to pay that amount out at termination, right? So an employee could use whatever they have in their sick leave bank, but if they have excess, you do not have to pay that out. You can cap the amounts at 56 hours a year, but you carry over whatever is accrued, okay? The other tricky thing is if you rehire someone within 6 months, you have to reinstate the sick leave that they had when they left. So that's a little tricky. You're supposed to also inform employees in writing each pay period how much sick leave they've accrued or have left. Record any approvals approvals or denials of sick leave. This next piece, my clients really don't like all the time, but you can only request a doctor's note for absences of 3 days or more. You can't request it just because someone was out for a day. But if the concern is always abuse, right? They can take this for whatever they want. They're not using it for sick leave. If somebody was silly enough to post like themselves on a rooftop having a daiquiri at 5 p.m. on Facebook or something, you could pull that sick leave back if we had credible evidence that they're abusing and we're not actually taking sick leave. You can then take it back. But most of the time, your hands are a little tied if it's under 3 days. If the leave is foreseeable, you can ask for 7 days notice, but other than that, employees can call in sick and take the sick leave. The whole point of this is not just the paid leave, but providing the time off for leave. So you have two kind of things going on there. How is this different from vacation under the SCA? Well, vacation under the SCA is a little different than you might experience outside of federal government contracting. This is a vesting system. The only employees that are eligible for the vacation time and the wage determination are those SCA non-exempt hourly employees, right? It's a little different from the sick leave. And technically speaking, an SCA employee is not eligible for any vacation until their anniversary date of employment. Anniversary dates are really important in the SCA. An anniversary date is not the first day they worked for you, but it could be the first day they worked for any other contractor on the same or similar contract at the same work location, at a similar work location. And that's kind of complicated, and that definition can be even more complicated depending on the industry and what work location means, right? Work location is where the contract anticipates the work may be performed. So if that moves, then the work location can move. So we generally say it's the same or similar work on like a follow-on contract. So someone, when you take over a contract, you are awarded a new contract or you're subcontracting to a prime, but this work has been going on for a number of years. You're just taking it over from another contractor. You might also make offers of employment to their people. And when you do, they bring with them that anniversary date. So it's important that you ask them, what their anniversary date on the contract is, not with a particular employer, but on the contract. Sometimes you can get a list. You're supposed to get a list from the contracting office, but 9 times out of 10, that doesn't happen. The amount of vacation then depends on how many years of continuous service someone has given on that contract, not just with you. So they might have already put in 15 years on a contract. They might get 3 or 4, sometimes 5 weeks of vacation, depending on what's in the wage determination. So I included an example here, but the wage determinations can vary. But the idea is that someone is not going to get any vacation until their anniversary date. If they started with you as their first employer on this contract, that anniversary date is going to align with their first day of employment. They work a full year without technically getting anything, and then they would get that full allotment of vacation on their anniversary date. So if my anniversary date was January 1st, I work a full year on January 1st, 2023. I get my full 1 week, 2 weeks of vacation, whatever in that wage determination. I have a full year to use that leave. And if I don't use it within that next year, I get paid out what's remaining, and I get another dump or bucket in my vacation allotment on my next anniversary date. This can be a little bit challenging when you're taking over the incumbent employees. And what can be frustrating about that is that you could have someone who hits an anniversary date your 5th day on the job. So you've been on this contract, working this contract for 5 days, and then you have employees getting dumps of 2, 3, 4 weeks of vacation. That can be kind of frustrating, but that's how the system works. And when that employee terminates, either because the contract comes to an end or because they quit or otherwise terminated, anything that's vested to them goes with them. They get paid out for it. So if your contract ends on 10/1, they get paid out the whatever's remaining in their bucket, start with you, or start with the next guy, and then they keep going until their anniversary date. They get their full bucket of vacation, and then so on and then so on. If you have someone who's irregularly scheduled or part-time, you can prorate their hours worked in the last year to determine how much vacation they're entitled to. Continuous service is also an important concept because if someone quits, they lose their service date. They lose that anniversary date and they have to start over. So a break in service occurs when the break is intended to be permanent. So it's not supposed to be like a temporary layoff. Like this came up a lot during March, April 2020 when COVID hit and came in a vengeance and sites kind of shut down. That was not intended to be a break in service, even if people were laid off, because it was supposed to be temporary. When it becomes permanent and somebody quits or gets fired, or it's intended to be more permanent, that's considered a break in service. If they come back to the contract, they start over with a new anniversary date. They start over from zero. You can use accrual. So this is the most common question I have is, what about accrual? Employees don't want to wait a year, or if they're incumbents, they don't want to wait 6 months. They want to get their vacation and they want to accrue it. The regulations are silent as to whether accrual is allowed or not allowed. It just gives you this vesting system, which can be frustrating. I've had a few DOL investigators over time that have given clients a lot of help for using accrual and maintain that the employee should still get their dump of vacation on their anniversary date. There are a couple of ways that you can do this. If you decide to accrue, first of all, I highly advise that you have an advance agreement that makes sure everybody understands that as they accrue, they're really being advanced vacation before they're eligible to have it. And they understand that this will be considered part of the vacation that they're owed on their anniversary date. You also have to keep in mind that anniversary dates don't just disappear because of accrual. So if you say take over from an incumbent on a contract, and let's just say you take over on October 1st, you start accruing people vacation and you have some anniversary dates that hit in December, you still have to make sure you true them up so that they get that full amount of vacation on that first anniversary date with you as the employer, and then you can continue to accrue after that. But you just can't lose sight of the fact that this accrual system doesn't always play well with the vesting system that's contemplated by the SCA. So you need to provide some workarounds. One popular workaround for some of my clients is to use some of that health and welfare money to provide a certain upfront bucket of vacation that can be used in the first year. Employees are also now getting sick leave that can be used in that first year, so it hopefully won't be as challenging as it used to be. Holidays. They're usually 10, now 11 per year, and I'm going to answer most questions at the end, but I do see one question about the Juneteenth holiday, which came about, last year, 2 years ago now. 2 years ago now is the first year that we had Juneteenth in wage determinations. Anytime there's an update to your wage determination that increases your cost, whether it's a holiday, whether it's increased H&W, whether it's increased vacation, increased wage rates, minimum wage rates, those are all costs that are incorporated into your change. Think about them as a change to your contract, and you are entitled to a price adjustment under 52222-43, the price adjustment clause for that holiday. So you will sometimes now see 12 holidays per year. There are a few counties in the country, in the South, some in the Northeast that already had 11 holidays. So you add Juneteenth to it and it's 12 holidays. The most important thing here is you can't assume that every wage determination has the same number of holidays, 11. You're going to see 10, 11, 12 are going to be the three numbers you're going to see most often. Don't assume they are the same for every single contract. You can provide different holidays than what's listed in the wage determination. You just have to put employees on notice that you're providing an alternative holiday. For example, some people work, on Veterans Day or Columbus Day, things like that. So you can pay cash in lieu of providing the holiday if you'd like. That's popular when you have independent contractors as well, or people are working through holidays. You can also provide, say, somebody's birthday instead of one of those holidays. You just have to make sure that they know how those holidays are going to be discharged. For part-time employees, you look at the hours worked in the week prior to the holiday and make sure they worked during the week of the holiday, unless they've taken previously scheduled leave. The best rule of thumb is if someone is always working 20 hours a week and they're regularly scheduled, you're going to provide them 4 hours of holiday pay. If someone works 10 hours one week and 30 hours another week, then you would prorate the holidays based on the hours they worked the week before the holidays. That's what we mean by irregularly scheduled part-time. Okay, so I wanted to mention, excuse me, I had a little nose itch there. I wanted to mention quickly the non-displacement of service employees. So non-displacement rules came about initially during the Obama administration. They were revoked under the Trump administration, and they've now come back under the Biden administration. It's confused, this yo-yo is kind of confusing, right? The final rules should be issued in July, and then you will see a FAR provision. So we've seen the proposed rules. Employers have been given the opportunity to comment on them, but they are not effective right now. And there's a lot of confusion out there because we had kind of a few years ago had the old rules and now we have these new rules, and there's some confusion out there, but we don't have a FAR provision yet. I anticipate they will use the same number as they did the last time. But basically what this thing is, when you see it, and you see the FAR provision in your contract, it is a requirement to provide a job offer to anyone who previously worked on the contract and generally worked at the same work location. So if you were taking over from another incumbent contractor, you could have an obligation to make a job offer to the people that the service employees, the non-exempt people that worked on that contract before. You don't have to have the same number of jobs. You could have fewer jobs, but if you do have a job available for one of those people, you have to provide them a written offer that you keep open for 10 days. There are some narrow exceptions to this, like when you have your own employees that were already employed by you, that were intended to fill those positions, you don't have to provide or keep that position open for an incumbent employee. Or if you have some information that would have given you just cause to terminate that person. That's a very high standard. I mean, think about coming in as a new contractor, how you're going to have information other than maybe a contracting officer saying this guy's bad, or a program manager you just hired saying this guy's or lady is bad. But that's usually not going to be enough. So when a contracting officer or someone says, hey, really don't hire that guy, sometimes you just have to hire them and then write them up, ship them out. Because this is a pretty restrictive regulation when it comes to hiring. But there are a few exceptions to this, but generally speaking, what you need to know is that when this FAR provision is issued again, likely end of summer, early fall, you should start seeing this in contracts again and solicitations. So subcontracting. What do you want to talk about subcontracting? So you have to make sure that you're flowing this down. If you have the SCA in your contract, the wage determination in your contract, and any modifications to your contract, you need to make sure that you flow those down to your subcontractors under the SCA. The prime contractor is ultimately responsible for any lower tier contractor's violations. So if you have an irresponsible subcontractor that just ignores this stuff and then skips town, they're going to come looking for you. These employees are going to get paid. And because the government doesn't have privity of contract with the subcontractor, the prime contractor is on the hook for all of that. This is especially important at the modification stage. So we see this often the terms of the prime contracts got flowed down to the subs, but then when those modifications come through, someone missed an update to a wage determination or something like that. It doesn't get flowed down to that subcontractor. The subcontractor never pays those wages and fringe benefits. And when DOL comes knocking, remember the SCA is a creature of contract. The DOL comes knocking and we say, not in our contract, not applicable to us, right? And go look to see if it was incorporated to the prime contractor. So then the DOL is going to go around, they're going to talk to the prime contractor or the contracting office, who's going to give them a copy of the contract. And if the prime contractor didn't flow it down to the sub, the prime contractor is going to be on the hook and possibly will have to pay, whatever it is that those employees have to be back paid because they missed it and they didn't do it right. So you want to make sure that those flow down provisions get done correctly. You also want to make sure that your subcontract really does protect you. You want to make sure that if you're the prime contractor, you have some right to inspect for compliance when you have a good faith reason to believe that there's non-compliance. Sometimes you hear whispers from employees or subcontract employees that they're not getting the new health and welfare, or they didn't get an adjustment to the minimum wage when they were supposed to. You'd much rather deal with it on your own than have to deal with it when the Department of Labor comes knocking. So I like to have some sort of inspection rate that's reasonable when there's a good faith reason to believe that there's an issue. You also want to make sure that there are good indemnification clauses on both sides, right? An indemnification clause is scary to some degree because it says, look, if we get sued by a third party because of something you did, you're going to pay us for it and you're going to pay our legal fees. And that's really scary, right? But the reality is that if the subcontractor screws something up or the prime contractor screws something up, and as a result, the other party is investigated and incurs legal expenses, it is, in limited circumstances, reasonable to expect that they will, they will take care of that so that you don't have to pay for it. So you don't want them to be overly broad, but you do want to make sure that subcontracts protect the parties, both as the subcontractor and as the prime contractor. So how does DOL enforce all this stuff? Well, this comes up in a number of different ways. Most often, an employee will complain. So 9 times out of 10, something happened, somebody's fired, someone didn't get their vacation on their anniversary date, someone heard that H&W had increased, and so they go and complain to the Department of Labor. An employee has no private right of action to just go to a lawyer and file in state court and say, hey, I'm not getting paid what I should get paid. DOL has the sole enforcement authority over SCA issues. The problem is that the Department of Labor's Wage and Hour Division that has these investigators, they are most often acquainted with regular commercial, Fair Labor Standards Act, exempt, non-exempt, whether somebody was paid, got their correct tip credit, things like that. It is harder to find experienced contract personnel at the Department of Labor and, frankly, at the agencies that are trying to appropriately put these clauses in the contracts and get you wage adjustments when you need to get them and all of that stuff. So you have a lot of inexperienced personnel on both sides of the house, so there's a lot of room for error. There's a lot of room for education, right? So if you do it in a very tactful way, often you can explain to the DOL, why the sick leave provisions don't apply to you yet because the FAR clause isn't in your contract. Why the minimum wage rules don't apply to you yet because the FAR clause wasn't incorporated into your contract. Or you didn't have the wage determination in the FAR provision in your contract from the get-go. Things like that are really important. The better you understand it, the more that you can gently push back and say, this is why we have an issue here. Oftentimes, DOL takes issue with the wage determination that was incorporated. Was it the right county? I just had an investigation that I'm working on now where the military base where this work is performed crosses 2 counties. And so the question is, well, what wage determination applied? You would think that if the wage determination crosses 2 counties, that the prevailing wage and fringe benefits in the area would be similar, but they're not. One has an additional holiday, one has different wage rates, and of course DOL is insisting that the one with the higher holiday number and wage rates should apply to this particular contract. Whatever they decide to change, the contracting office is going to update and modify the contract. They're going to give it to you, and then you are going to implement it and then provide the back wages if it's backdated to the workforce, and then go out and ask for a price adjustment from the government. Don't rely on advice from agency officials. It's not a good defense. So if a contracting officer representative says, hey, don't worry about this, or they've always been classified as general clerks, or they've always been classified as this or that, don't rely on that. Remember, one of the highest cost issues that contractors have is misclassification. and the classification is generally all on you. So, you know, it might be a place to start if you receive a tip as to how these people were classified before, but you really need to make sure it checks out from a work performance issue. If DOL finds that there have been violations and you refuse to comply, there are a number of steps that they can take to ensure compliance. So first, they can engage in what we call a withholding letter. So if you have a disagreement with the Department of Labor, you still have due process. You can still go to a hearing, but while the hearing is pending, they can go to your government agency and say, I think ABC company owes $100,000 in back wages to employees. So I want you to withhold $100,000 on their invoices. We're going to put it in this nice little account over here off to the side. And once they go through the due process, whole process, the hearing and all the things, then we will release that back to them after they appropriately pay employees. So they're just saying these people are going to get paid, and we are not going to wait until you skip town in order to withhold that money. You do have a right to respond to that letter, but that's how that works. They can also refer you for suspension and debarment. So under the SCA, the de facto rule is that if you violate the SCA, you're going to be referred for suspension and debarment. Now, I will say that doesn't happen often, but it does happen, particularly if you ignore the Department of Labor. They don't like being ignored. And so if you get a notice from the Department of Labor to investigate, it's a good idea to contact counsel and also to respond to the Department of Labor. Work with them, communicate with them. You don't have to agree with them, but you can communicate with them, right? Before we get to all of these parade of horribles, the withholding, suspension and debarment, all this nasty stuff, there's a good opportunity to engage in a discussion about whether the SCA was properly incorporated, whether people were paid correctly, whether they received the right amount of holidays, fringe benefits, all of those things. The DOL can also retroactively apply the SCA. So if the SCA wasn't properly incorporated into your contract, they can go back to the start of the contract and apply it, which is why you can get pretty hefty back wage application. And let's just say it wasn't your fault, it was completely the contracting agency's fault. DOL is still going to ask for very swift payment to employees. You can still go out and get that price adjustment, but the timing doesn't always line up. So we try to work as hard as we can to get the timing to line up, but often it does not.
Okay, great. Thank you again, Nicole. And thank you to all of our attendees.